Hello, my name is Tony Lajeunesse, CEO and President of TL Financial Group. Today's March vlog is going to inform you of key estate planning documents you need. In my years of experience, there are 5 key planning documents you may need, regardless of your age, health, or wealth. They are durable power of attorney, advanced medical directives, a will, letter of instruction, and a living trust. The last document, a living trust, isn't always necessary, but it's included here because it's a vital component of many estate plans. Durable power of attorney, let's start with that one first. A durable power of attorney, or DPOA, can help protect your property in the event that you become physically unable or mentally incompetent to handle financial matters. If no one is ready to look after your financial affairs when you cannot, your property may be wasted, abused, or lost. A durable power of attorney allows you to authorize someone else to act on your behalf so he or she can do things like pay everyday expenses, collect benefits, or watch over your investments and file taxes. Now, there are 2 types of durable powers of attorney. There's an immediate durable power of attorney, which is effective immediately. This may be appropriate, for example, if you face a serious operation or an illness. And then secondly, there's a springing durable power of attorney, which is not effective unless you have become incapacitated. Caution, a springing durable power of attorney is not permitted in some states, so you'll want to check with your attorney. There are, however, permitted in the state of Michigan. Advanced medical directives. Advanced medical directives let others know what medical treatment you would want, or allows someone to make medical decisions for you in the event that you cannot express your wishes yourself. If you don't have an advanced medical directive, medical care providers must prolong your life using artificial means, if necessary. With today's technology, physicians can sustain you for days and weeks, if not months or even years. There are 3 types of advanced medical directives. Each state allows only a certain type or types. You may find that 1, 2, or all 3 types are necessary to carry out all of your wishes for medical treatment. Just make sure all documents are consistent. First, a living will allows you to approve or decline certain types of medical care, even if you die as a result of that choice. In most states, living wills take effect only under certain circumstances, such as a terminal injury or illness. Generally, one can be used only to decline medical treatment that serves only to postpone the moment of death. In those states that do not allow living wills, you may still want to have one to serve as evidence of your wishes. And second, a durable power of attorney for healthcare, known as a healthcare proxy in some states, allows you to appoint a representative to make medical decisions for you. You decide how much power your representative will or will not have. Finally, a do not resuscitate order, or DNR, is a doctor's order that tells medical personnel not to perform CPR if you go into cardiac arrest. There are 2 types of DNRs. One is effective only while you're hospitalized. The other is used while you're outside the hospital. All right, let's talk about getting a will. A will is often said to be the cornerstone of any estate plan. The main purpose of a will is to disperse property to heirs after your death. If you don't leave a will, disbursements will be made according to state law, which might not be what you would want. There are 2 other equally important aspects of a will. One, you can name the person, which is the executor, who will manage and settle your estate. If you do not name someone, the court is going to appoint an administrator who might not be someone you would choose. And then 2, you can name a legal guardian for minor children or dependents with special needs. If you don't appoint a guardian, the state is going to appoint one for you. Keep in mind that a will is a legal document, and the courts are very reluctant to overturn any provisions within it. Therefore, It's crucial that your will be well written and articulated and properly executed under your state law. It's also important to keep your will up to date and located in a secured area. Next, letter of instruction. A letter of instruction, also called a testamentary letter or side letter, is an informal, non-legal document that generally accompanies your will and is used to express your personal thoughts and directions regarding what is in the will or about other things, such as your burial wishes or where to locate documents. This can be the most helpful document you leave for your family members and your executor. Unlike your will, a letter of instruction remains private. Therefore, it is an opportunity to say things that you would rather not make public. A letter of instruction is not a substitute for a will. Any directions you include in the letter are only suggestions and are non-binding. The people to whom you address the letter may follow or disregard any instructions in it. And lastly, a living trust. A living trust, also known as a revocable or inter vivos trust, is a separate legal entity you create to own property, such as your home or your investments. The trust is called a living trust because it's meant to function while you're alive. You control the property in the trust, and whenever you wish, you can change the trust terms, transfer property in and out of the trust, and end the trust altogether if you wish. Not everyone needs a living trust, but it can be used to accomplish various purposes. The primary function is typically to avoid probate. This is possible because property in a living trust is not included in the probate estate. Depending on your situation and your state laws, the probate process can be simple, easy, and inexpensive, or it can be very complex, resulting in delay and also making it very expensive. This may be the case, for instance, if you own property in more than one state or in a foreign country, or have heirs that live overseas. Furthermore, probate takes time, and your property generally won't be distributed until the process is completed. A small family allowance is sometimes paid, but it may be insufficient to provide for the family's ongoing needs. Transferring property through a living trust provides for a quicker, almost immediate transfer of property to those who need it. Probate can also interfere with the management of property like a closely held business or a stock portfolio. Although your executor is responsible for managing the property until probate is completed, he or she may not have the expertise or authority to make significant management decisions, and the property may lose value. Transferring the property with a living trust can result in a smoother transition in management. Finally, avoiding probate may be desirable if you're concerned about privacy. Probated documents, like your will and inventory, end up becoming a matter of public record. Generally, a trust document does not become a matter of public record. Caution: although a living trust transfers property like a will, you should still also have a will, because the trust will be unable to accomplish certain things that only a will can, such as naming an executor or a guardian for minor children. Tip: there are other ways to avoiding the probate process besides creating a living trust, such as titling property jointly or setting up your bank or investment accounts as TOD or POD, which means transfer on death or pay on death. In that case, after your death, those items go directly to the beneficiary that is listed on that account. I hope that you found today's information about estate planning valuable to you. It really is an important topic, and it's oftentimes overlooked. So please be proactive, consult with an attorney or a financial planner that can help guide you to the appropriate planning that is relevant and important to you. It's a lot easier to avoid a mistake than it is to correct one. As always, if you have any questions for me, please feel free to reach out. Thanks. Have a great day.